Assalamualaikum warahmatullahi ta'ala wabarakatuh. Good day po, Ma'am Attorney. Good day, classmates. My report will be about the third section under the fourth chapter of the law of sales, which is obligations of the vendor. The third section is actually about conditions and warranties, and I will be discussing to you Articles 1545 to 1554. All right. So let's proceed with Article 1545, Article 1545. It says, where the obligation of either party to a contract of sale is subject to any condition which is not performed, such party may refuse to proceed with the contract or he may waive performance of the condition. If the other party has promised that the condition should happen or be performed, such first mentioned party may also treat the non performance of the condition as a breach of warranty. Additionally, where the ownership in the thing is not passed, the buyer may treat the fulfillment by the seller or his obligation to deliver the same as described and was warranted expressly or by implication in the contract of sale as a condition of the obligation of the buyer to perform his promise to accept and pay for the thing. Okay, so what do we get from that, right? Firstly, we understand the meaning of condition. So, what actually is condition? A condition, as used in Article 1545, actually means an uncertain event or contingency on the happening of which the obligation of the contract depends. In such a case, the obligation of the contract does not attach until the condition is performed. Ayan, di ba? So merong non-fulfillment of the condition. And it says here na it is an uncertain event or contingency on the happening of which the obligation of the contract depends. And so, hindi nag-a-attach yung obligation ng kontrata until maisagawa yung condition. Okay. Now, what are the effects of non-fulfillment of condition? Right? So, una sa lahat, we know that a contract of sale may be absolute or conditional. That is from Article 1458. But what are the effects kapag hindi na fulfill yung condition? One, or firstly, if the obligation of either party is subject to any condition and such condition is not fulfilled, such party may either A. Refuse to proceed with the contract, or B. Proceed with the contract waiving the performance of the condition. Meaning, kapag ka ang obligation ng kung sino mang party ay hindi natupad, ang party ay pwedeng hindi tumuloy sa kontrata o tumuloy sa kontrata pero mawa-waive na or matatanggal na yung kailangang pagsagawa ng kondisyon. Now, secondly, if the condition is in the nature of a promise that it should happen, the non-performance of such condition may be treated by other party as a breach of warranty. Let's say, for example, how do we use that? How do we contextualize that, right? So, let's say, for example, eto si B, nag-enter siya sa contract with S. Bibili para sa pagbili ng isang machinery. Ngayon, ang pagdating ng mga goods to be shipped from Japan is made of a condition of the bargain, there being no promise by S that the goods will arrive. So pag hindi dumating yung machinery, S is not guilty of breach of contract. Kasi walang promise by S that the goods will arrive. However, if nag-promise si S or if nag-warrant siya na darating talaga yung machinery or na-ship na yung machinery or na on the way na yung machinery, pag hindi dumating yung machinery, ito ay magiging breach of contract. Ayan. So, ganyan siya, di ba? So, yun yung yung ating isang example. Another example is nag-promise si S that S will sell his parcel of land to B. Should S win a case pending in the Supreme Court? Kaso, natalo si S. So, S may either refuse to sell the parcel of land or he may waive the performance of the condition and sell the parcel of land. So, yan naman siya applicable sa unang effect na ating binanggit. Si S, natalo siya dun sa kaso, ang kondisyon ay yung manalo siya sa kaso. Therefore, pwedeng si S ay hindi niya ibenta yung lupa or pwede rin ibenta niya yung lupa pero i-waive na niya yung performance of condition. So that's how we put it into examples. Proceeding to the next article, Article 1546, any affirmation of fact or any promise by the seller relating to the thing is an express warranty if the natural tendency of such affirmation or promise is to induce the buyer to purchase the same, and if the buyer purchases the thing relying thereon. No affirmation of the value of the thing, nor any statement purporting to be a statement of the seller's opinion only, shall be construed as a warranty unless the seller made such affirmation or statement as an expert and it was relied upon by buyer. Okay, so it's pretty self-explanatory, but let's delve deeper, right? So, a warranty actually means any representation made by the seller of the thing with respect to its character, quality, or ownership, by which he induces the buyer to purchase the same, relying on said representation. So, take note of the word induce. So, there is only warranty kapag ka ang sinabi ng seller ay base sa isang kanyang expertise o na yung kanyang sinabi ay para i-induce o like pilitin or like i-convince yung kanyang buyer na bilihin yung kanyang binibenta. So, saka lang siya matatawag na warranty. Okay? Saka lang siya matatawag na warranty. Okay, now what are the kinds of warranty, right? It may be express or as in the above article or previous article implied. So what is an express warranty? An express warranty is, as in the above article, is any affirmation of fact or any promise by the seller relating to the thing, the natural tendency of which is to induce the buyer to purchase the thing, and the buyer thus induced does purchase the same. So there's only express warranty kapag ka merong affirmation of fact o merong promise by the seller na related doon sa bagay na kanyang binibenta, at kapag ka dahil doon ay talaga ding bumili si buyer or nag-rely si buyer doon sa kanyang sinabi. So we need to understand that difference there is a difference between yung ating express warranty at express warranty o warranty at yung pagsisale stock lang, 'di ba? So we will understand that later. But anyway, a warranty is actually a part of the contract of sale. So therefore, immaterial whether the seller did not know that it was a false or true. Immaterial siya. So there's no intent necessary to make the seller liable for his warranty. Let's place it to an example, di ba? So, si S, nagbenta siya kay B ng isang kotse for 60,000, telling that it is a 1990 model and that it is worth about 70,000. Si B, tinignan niya yung automobile and after a test run, satisfy naman siya over the condition, and the automobile without his knowledge is actually 1988 vintage and is worth only 50,000. Ngayon, si B, wala siyang right of action for breach of warranty because ang inducing cause of the purchase o yung dahilan or pinakadahilan ba't siya na-convince bumili is not the erroneous statement as to its model and value, but B's reliance on its appearance and demonstrated condition. Once again, let us understand that B actually bought the car from S because of its appearance and condition, not really because it is of 1990 model or because of its price. Therefore, walang breach of warranty kasi hindi yaon ang dahilan ni B sa pagbili at walang liability doon si S. Okay. But the statement that the automobile is in excellent running condition constitutes a warranty if such is not a fact. Therefore, yung pagsabi ni S na ang automobile o ang kotse na yon ay nasa excellent running condition, nagko-constitute yun ng warranty kung for example ay hindi pala yun totoo. Okay? Okay, but we need to understand that 'di ba alam natin na merong mga nagsisale stock sa mga malls sa ating binibilhan and all that. We need to understand that a mere expression of opinion, no matter how positively asserted, does not import a warranty unless the seller is an expert and that the opinion was relied upon by the buyer. Thus, assertions that our things are fine or valuable or better than products of rival manufacturers are in their nature so dependent on individual opinion that no matter how positive the seller's assertion may be, they're not held to create a warranty. So we need to understand that unless ang binigay na statement ay based on expertise and that it is something that has induced the buyer completely, it will not constitute a warranty. Ayan. Proceeding to the next article, Article 1547, in a contract of sale, unless a contrary intention appears, there is one, an implied warranty on the part of the seller that he has a right to sell the thing at the time when the ownership is to pass, and that the buyer shall from that time have and enjoy the legal and peaceful possession of that thing. And second, an implied warranty that the thing shall be free from any hidden faults or defects or defects or any charge or encumbrance not declared or known to the buyer. But this article shall not, however, be held to render liable a sheriff, auctioneer, mortgagee, pledgee, or other person professing to sell by virtue of authority in fact or law for the sale of a thing in which a third person has a legal or equitable interest. Okay, but what do you mean by implied warranty, right? So warranty is actually which the law derives by implication or inference from the nature of transaction or the relative situation or circumstances, irrespective of any intention of the seller to create it. So we need to understand that when we mean implied warranty, although it is not explicitly expressed, there is still an inference of that warranty, or it is somehow implied base sa nature ng transaction o doon sa kanyang kasangga o katulad na sitwasyon, 'di ba? Okay. So warranties actually will be expressed or implied, but as we have mentioned in Article 1547, implied warranty to siya, di ba? So it is actually reserved for cases where the law attaches an obligation to the seller which is not expressed in any words, di ba? What are the examples? Implied warranty as to seller's title, implied warranty against hidden defects or unknown encumbrances, implied warranty as to fitness or, and finally, implied warranty as to fitness or merchantability. Ayan. Now there's a subsection 1, di ba, under the section 3, which is warranty in case of eviction. Okay. Okay, what is warranty in case of eviction? Article 1548 states that eviction shall take place whenever by a final judgment based on a right prior to the sale or an act imputable to the vendor, the vendee is deprived of the whole or a part of the thing purchased. So the vendor shall answer for the eviction, even though nothing has been said in the contract on this subject. The contracting parties, however, may increase, diminish, or suppress this legal obligation of the vendor. Okay, so what does eviction mean? Eviction may actually be defined as the juridical or the judicial process whereby the vendee is deprived of the whole or part of the thing purchased by virtue of a final judgment based on a right prior to the sale or an act imputable to the vendor. Once again, ang eviction ay pwede natin siyang ma-define as the judicial process where ang pinagbentahan ay matatanggalan ng karapatan sa buo o maaaring parte lamang ng kanyang bagay na nabili base sa final judgment, di ba? Based on a right prior to the sale or maaaring sa isang act na imputable sa vendor. Okay. So, ayan. Types of eviction. Eviction may be total or partial. Maybe total or partial. Ang eviction ay total when the vendee is deprived of the whole of the thing purchased. Once again, ang eviction ay total kapag ka ang pinagbentahan ay na-deprive o natanggalan ng buong bagay na kanyang binili. At ang eviction naman ay partial kapag ka ang vendee ay tinanggalan ng karapatan sa parte lamang ng kanyang nabili o na kapag meron siyang mga nabili na deprived siya doon pero may kasabay na ibang gamit which is hindi siya doon deprived. Or finally, kapag ka ang hindi ang nabenta or nabili niya which is hindi magala or immovable ay should be encumbered with any non-apparent burden or servitude not mentioned in the agreement of such a nature that it must be presumed that the vendee would not have acquired it had he been aware thereof. Ayan. Okay, so ang liability nga pala ng vendor ay waivable. How so? Warranty is not an essential element of a contract of sale and may therefore be increased, diminished, or suppressed by agreement of the parties. Any stipulation, however, exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. But if he didn't act in bad faith, then the liability of the vendor is actually waivable. Article 1549, the vendee need not appeal from the decision in order that the vendor may become liable for eviction. Once again, the vendee need not appeal from the decision in order that the vendor may become liable for eviction. Hence, vendee has no duty to appeal from judgment. So, yung right ng vendee against sa vendor is hindi mawawala because ang vendee hindi nag-appeal. So, with the judgment becoming final, whatever be the cause of finality, the requirement of the law is deemed satisfied. Therefore, or furthermore, the vendor, having been notified of the action, could have very well followed up the case and made use of all possible remedies. So if hindi niya yun ginawa, he should suffer for his omission. And in reality, he does not have the right to demand of the vendee such diligence that he himself did not have and which he was more obliged to observe as the vendor, especially if the cause of eviction was prior to the sale. Ayan. Article 1550, when adverse possession had been commenced before the sale, but the prescriptive period is completed after the transfer, the vendor shall not be liable for eviction. Once again, when adverse possession had been commenced before the sale, but the prescriptive period is completed after the transfer, ang vendor shall not be liable for eviction. Okay. What are the effects of prescription? By prescription, by the way, we mean or it means one acquiring ownership and other real rights to the lapse of time in the manner and under the conditions prescribed by law. In the same way, rights and actions are lost by prescription. Effects of prescription if it was completed before sale, if it was completed after sale. So if before sale, maaaring mawala sa vendee ang kanyang biniling gamit. Maaaring mawala ang kanyang biniling gamit sa third person who has acquired title thereto by prescription. Ayan, so when prescription has commenced to run against the vendor and was already completed before the sale, the vendor can enforce the warranty against eviction. In this case, the deprivation is based on a right prior to the sale in an act imputable to the vendor. But if it's completed after sale, even if the prescription has started before the sale but has reached the limit prescribed by law after the sale, the vendor is not liable for eviction. The reason is because the vendee could easily interrupt the running of the prescriptive period by bringing the necessary action. So if however, if yung property na nabenta is, for example, isang lupa na registered under the torrent system, Article 1550 will have no application because under the torrent system, ownership of land is not subject to prescription. So one example si S nagbenta siya kay B ng parcel of land o kay lupa which is kinlaim ni C na which is si C is may possession na nitong property in the concept of owner publicly and continuously for 30 years. Sa ilalim ng batas, si C deemed to have acquired ownership over the land by prescription siya. So no need for title, no need for good faith. Sa kasong ito, si S will be liable to B in case of eviction. Okay? Magiging liable si S kay B in case of eviction. But, in the same example, C was in an adverse possession of the land for only 25 years at the time of the sale, and the prescriptive period is completed after the sale. Si S, hindi siya magiging liable kay B in case of eviction kasi si B, pwede naman siyang mag-bring ng action against C during the remaining 5-year period para ma-recover ang property na yaon. Ayan. Article 1551. If the property is sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. Ayan. So, kung if si vendee is na-deprive siya ng ownership ng property because nabenta na pala yung property sa public auction dahil sa non-payment of taxes due ng vendor, ang si vendor ay liable siya for eviction and liable siya for an act that is imputable to him. It is required, however, that at the time of the sale, the non-payment of taxes was not known to the vendee. So kung alam nung vendee, alam nung pinagbentahan na meron palang na nabenta na pala yung lupa for non-payment of taxes, then the vendor cannot be held liable for this act. Article 1552. The judgment debtor is also responsible for eviction in judicial sales unless it is otherwise decreed in the judgment. So while the rule on implied warranty does not apply to a sheriff who sells by virtue of authority in law, the judgment debtor is responsible for eviction and hidden defects. So even in judicial sales unless otherwise decreed in the judgment. Article 1553. Any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Once again, kapag kasi vendor ay nag-act in bad faith, kapag kasi vendor ay may ginawang hindi tama o may ginawang pagkakamali or may ginawa na masama, then ang kanyang obligation na maging exempted sa eviction ay magiging considered na void. Ayan. So, okay, so say for example, stipulation waiving warranty, di ba? So, effective vendor's bad faith. So, the vendor's bad faith under Article 1553 consists in his knowing beforehand at the time of the sale of the presence of the fact giving rise to eviction. Thus, if the vendor, after selling his property to another, sold it again to another purchaser, he cannot, even by stipulation, be exempt from warranty against eviction because he acted in bad faith. Effect of Vendi's bad faith, what if si binentahan siya naman ng nag-act in bad faith? It is a requisite, however, that the vendee is not himself guilty of bad faith in the execution of the sale. So if alam niya may defect na sa title, doon pa lang sa time ng pagbenta, hindi niya pwedeng i-claim na niloko siya ng vendor o na niloko siya ng vendor o na that the vendor had actually warranted his legal and peaceful possession of the property sold. Nag-proceed siya sa sale with the assumption of the risk of eviction and therefore is not entitled to warranty against eviction nor to right to recover damages. But finally, if the vendee has renounced the right to warranty in case of eviction and eviction should take place, the vendor shall only pay the value which the thing sold had at the time of the eviction. So, should the vendee have made the waiver with knowledge of the risks of eviction and assumed its consequences, the vendor shall not be liable. So, there are actually two kinds of waiver of eviction. First being the consciente, that is, the waiver is voluntarily made by the vendee without the knowledge and assumption of the risks of eviction. And second, intentionada, that is, yung waiver ay ginawa siya ng pinagbentahan o ng vendee with knowledge of the risk of eviction and with the assumption of its consequences. Okay. Ano ang effect ng waiver by vendee? So, if ang waiver happened by conscious, which is itong consyente, the vendor shall only pay the value which the thing sold had at the time of eviction. However, if sa second kind of waiver, which is yung intentionada, the vendor is exempted from the obligation to answer for eviction, provided that he did not act in bad faith. And with all of those being said, that is the end of my discussion for articles 1545 to 1554. Assalamu alaikum.